Hello, everyone, and good afternoon. This is Michael Misko with Misko Health Law, and we're here to have another Cairo Secure Managing Risk um, session this afternoon. I'm going to take about 10 minutes of your time, and today we're going to talk about the Medicare appeals process and how it works, the costs, and how you avoid an overpayment demand in the event that you get caught up in that process. Now, if you're still billing Medicare, there's a significant risk that at some point in time you're going to get audited, especially based upon what your profile looks like in terms of average visits per week. When that number gets too low, it means your visits are stretched out. And increases the likelihood that they're going to be able to determine that your care is maintenance care. Um, Care goes too long, too many visits per patient or per condition, the type of diagnosis. There's a number of profile audits that they run, but the likelihood that you're going to bill Medicare on a reasonably frequent basis and avoid a post payment audit is somewhat unlikely. It is possible, but there's really no way to fly under the radar with Medicare. Although we will talk about some risk mitigation strategies at the end. Once you get audited by Medicare, the first thing that'll happen is you will get a records request, usually from what's called a Unified Program Integrity Contractor, and there are a number of those throughout the country. So depending on where you are, will determine who your UPIC is. It is possible that your own Medicare administrative contractor could start an audit, but usually anymore they don't. They defer they send that stuff over to the UPICs and let them do the auditing. Now, the UPIC will request records. Usually, it is what is called a probe audit, and they will request select records for certain patients and certain dates. Possibly, they select claims, which will, if your claims include multiple dates, there may be um, as many as 40 or 50 dates of service in a probe audit. Now, if they do a broader sample, what they call statistically valid random sample, then you're looking at potentially a lot more claims being involved in the record. But because the reason that they do that is they want to be able to project the error that they find in the sample to the entire universe that the sample was drawn from. And there's a statistical process for doing that. And there are, of course, challenges as to whether they do it right or not. But usually it's very difficult to get one of those statistical projections overturned, even though we can find some substantial error with their mathematical process. That being said, when you get a request, you have to look at it very carefully and look at and understanding that medical necessity is always on the table. You need to send all the records that pertain to the dates of service they're requesting. So, for example, if they pick patient Joe Smith and date of service October 19th, 2019, uh, that patient may have been treated on that date, and I certainly expect that they would, and you would have the note for that, the treatment note for that visit. But it would behoove you, because they're going to evaluate medical necessity, to look also at providing the initial evaluation for that course of care, any progress evaluations in the interim, radiographs, all of the stuff that pertains to the entire course of care that the visit that they want is part of. As an analogy, consider I ask you for one page of the book, you send it to me, and then you wonder why I'm confused as to what the book's about. So we want to definitely send the entire story. Now, if they're asking you, you do not want to send all the records back to the beginning of time. So some of these patients you may have seen for more than 10 years. But what you need to do is identify when the condition that you were treating on the date that they're asking for, when did it start, provide that exam and plan of care. And hopefully you have that. Um, so once you get the records sent in, they'll do what they do. They will publish what is called an initial determination. Okay, an initial determination is a letter. It'll usually come with a compact disc, a spreadsheet that has um, their claim or service specific findings on it. And um, with that, that tells us the specific reason that they denied each claim. So with that in mind, once we have that, the next thing that's going to happen, and there may be a provider education letter and some claim detail findings. Different UPICs do it differently. But once they publish their initial determination, a copy of that goes to your Medicare administrative contractor. They will take those findings, put them back in their system, and essentially reverse the payments, and that will generate a what's called an MMA 935 initial request, which is a payment demand letter in the vernacular. You might get one or more. Even if it's a small audit, they may break it up into multiple demand letters. But you need to make sure that you have them all. And when you do, your appeal time frame starts is based upon the date of the earliest demand letter. So you'll want to aggregate an appeal, of course, but you do not want to get into a situation where you're appealing each claim individually, because it'll create a paperwork nightmare for you later on, or for your lawyer, if you decide to get legal help. Once you submit, now the way the timing works, if you have the money, pay the money back as soon as possible. Interest starts accruing at ridiculous rates, somewhere between 9 and 10.5%, depending on where the CPI is at the moment and where the prime interest rate is. But it is an exorbitant interest rate. So even if it's a projected amount and it's a rather large number, if you have the resources, pay it back. If you can borrow the money, pay it back, because commercial rates are less than what the government is going to charge you. Interest will start accruing 30 days beyond the date of the demand letter. So even if we're appealing, interest will continue to accrue, and because of the appeal timeframes, you don't want that to happen, because the interest amount will be substantial when the issue is finally concluded at the administrative law judge level or beyond. Now, that 30-day period is also significant, because not only does it signal when interest starts to accrue, but it also signals when Medicare will begin recoupment. So if you file your appeal within that 30-day time frame, you will stop recoupment, but you will not stop interest. Now, the interesting thing is that the regulations give you a whole 120 days to appeal an initial determination. So to give us time, or to give yourself time to prepare an appeal, potentially get independent expert analysis, what you usually do is, if you pay the money back, then you don't have to worry about recoupment at all. Or if you can't, then you hold your claims until we can get the appeal filed. And then once the appeal's filed, then recoupment will stop. Then you can, I supposedly, submit claims for a little bit. Once the initial or the redetermination request goes in, that's the appeal of the initial determination. That goes to your Medicare administrative contractor. It will probably be rubber stamp denied. Once that determination comes down, it's due within 60 days of when they get it. Then the next level is reconsideration. Again, 30 days to file the appeal to avoid recoupment if you haven't already repaid the money. And you have 180 days otherwise to file that appeal. And usually we take the maximum amount of time, and I'll explain why later. Once that appeal is filed, that goes to what's called a qualified independent contractor. This is the second level of appeal. And that is either somebody like C2C Innovative Solutions or Q2 Administrators. They will evaluate the appeal, most cases, rubber stamp whatever the initial determination said, and issue their unfavorable determination. At that point, we have 60 days to file a request to the Office of Medicare Hearings and Appeals for an administrative law judge hearing. Once the reconsideration comes down, if you have not paid the money back and you're continuing to bill claims, they will institute recoupment. There's nothing I can do to stop it. If you are not submitting claims, we'll start getting letters from Treasury, the United States Treasury, to start repayment. And again, interest continues to accrue. I think it's currently somewhere between 9.5% and 10%. So it's a significant interest rate. So try to avoid that if you can. Now, once we file for an administrative law judge appeal, I am seeing smaller cases, little probe audit cases. They're coming back in about 2 years. Cases that I filed in 2019 are going to hearing now. and they were filed in early 2019, so they're about 2 years old. I have larger cases involving statistical projections that I filed in 2015 that just went to hearing. So the time frame, how Omaha is working off its backlog is a mystery, but so you're probably looking at 2 to 5 years potentially for an ALJ hearing, which seems like an enormous amount of time uh, to waste, especially if it's a probe audit with a relatively small amount. So you may be asking, why would I even bother to appeal it in the first place? And the answer is because it's not so much what they identified in the audit in a probe audit that I'm concerned about. It's the voluntary disclosure risk that that audit creates. Under the Fraud Enforcement Recovery Act and the ACA changes to the Social Security Act, um, and more specifically the False Claims Act, they created this obligation to refund any overpayments to Medicare that you know or should know about. And it's the should know about part that gets a little tricky. In the regulations, in the comments of the final regulations relative to that rule, Medicare made it very clear that even an audit of a single claim can put you on notice of potential overpayments, thereby triggering an obligation for you to go investigate uh, and identify any overpayments. And once they're identified, you have 60 days to disclose and refund them. Otherwise, they become per se false claims, which subjects you to treble damages. So we consistently, 900, $1,500 audits, where in the past I would have just told the provider, write the check, make correct, do the corrective action, go forth and sin no more. We can't do that because if we accept the audit result and then don't do the disclosure and refund, which is a look back of 6 years potentially, even though they can only audit looking back 5 years presently, um, there is usually a significant overpayment disclosure liability if we accept the audit, and that's why we appeal it. Having said that, once you get uh, the length of the process, effectively, even if we lose at the end, we've pretty much run out the disclosure liability for the time period of the audit and anything prior to that, because that time period would be more than 6 years old. So it was as much as 4 years old when the audit was generated. It'll be more than 6 years old by the time the audit is concluded, because we're going to spend a year going through the first two levels of appeal. We'll spend another 2 years probably waiting for, or longer, waiting for an ALJ hearing. So even if we lose in the end, we've solved the problem of our disclosure liability. And that doesn't mean that we don't care about the result. We do, especially if it's a statistical projection. And even those, even though they cover the period of the universe, they don't cover the entire disclosure period. So even if your projection was a feasible number for you, it would not encompass your total liability. So an appeal is the only way we avoid that obligation. Now, costs. Usually the process involving experts, and that's where the real expense is, and that expense varies depending on the structure and completeness of your records, and how hard we have to look, and whether attestations are necessary. There's a whole bunch of factors that drive expert costs. But between experts and legal costs through an ALJ hearing without a statistical projection, easily 20 grand. It's an expensive process because it is very methodical. And sometimes the carriers don't play by the rules. They change the reason for denial, requiring more expert work. So it can be messy. If there is a statistical projection and we need a statistician, then there's a process of trying to get the information out of them, FOIA requests, whatnot. And there's a whole lot more work, and those ones can get a lot more expensive. So that just gives you an idea how much we spend even on a small audit, when you have a couple $100,000 worth of disclosure liability uh, uh, on your plate. So that's why we spend that kind of money. Now, I told you I'd tell you about risk mitigation. Read your LCDs and the Medicare Benefit Policy Manual carefully. They have initial and subsequent visit documentation requirements. Comply with them explicitly. Remember that just because a patient has a symptom doesn't mean that we're going to bill. They need a significant problem. It requires a course of care. Patient's got to show up for it. But when you have a start and a finish, and you can demonstrate objective, measurable change, that is how you're going to avoid liability. The final thing I'll mention about the initial visit documentation requirements regarding a treatment plan: frequency, duration, and they have specific goals and objective measures to evaluate treatment effectiveness. All the contractors that evaluate chiropractic claims have kind of morphed that into an obligation to create objective measurable goals, which is kind of silly, but that's what they require. So there, you'll have to kind of identify your associated neuromusculoskeletal conditions, identify their severity, like on a 0 to 10 scale, set goals. So if their cervical radiculitis is a 7, you want to get it to a 3. You can couple it with outcome assessment, although those are subjective measures. So be careful relying on those exclusively. If you have range of motion, of course, that's objectively and measurable, but usually that's not always going to be a significant component of the problem. It can be, and if it is, you can use it. But you'll need to identify what your goals are, and then periodically throughout care, evaluate the patient and note the objective change. If I could tell providers one thing that you can do better to win medical necessity fights is quit redocumenting the problem. We already know what it is. All you need to focus on in subsequent visits and progress analysis is how your treatment changed the status of that problem. And if you do that, you'll be in much better shape. Be sure to document subluxation by part or x-ray, explicit part documentation, or explicit x-ray findings that are timely. Because you mess that up, that's a statutory condition of payment, and there's not much we can do with it. Um, that's about all we have time for. I know we went a little long today, but that is a little bit deeper subject. I look forward to your continued participation in this Growth Without Rest series. And next week, I think we have Dr. Sherry McAllister, and she will have a riveting topic, I am certain. Thanks, everybody, and have a great rest of your day.